From 8th of December up until the launching of this application, the uncertainty exists over how payments will be made to the 2.8 million people. There's unanimity, there's support from the old minister, the new minister, the three other parties before you today, including the fourth party, SAPO, do not oppose the relief which is sought. If the court requires, I can give the references where all the parties, in fact, agree that it is necessary to give the order. CPS, in fact, qualifies it. It says subject to a reasonable fee, and it's a matter which I'll deal with shortly. Before I go on to the cash payment structure going from the 1st of April, just a word about the contract with the post office. What this really involves is changing the old SASSA card into the new SASSA card. It's going to be a process because, as the court will appreciate, CPS has been prevalent for the last 5 years, if not more. The old SASSA card involves a domain of Net1, which is administered by CPS, and what is required is to move on to the new SASSA card, which will have the domain of the post office. To return to the observation of the panel of experts, and they said, look, ideally, all the beneficiaries, or recipients rather, must have bank accounts. It would be remiss for me not to point out two aspects of that particular scenario.
As you point them out, your 5 minutes is up.
As the court pleases. 2 points I want to make. First is the cost of administering a bank account, which vacillates currently between 7 rands and 55 rands per account. And the second and more fundamental aspect is this. When the money is deposited into the recipient's bank account, control is lost on how the social grantee can control that money because of debit orders. I now want to move on to the cash payment structure, which is the subject matter of this application. Currently, as I've pointed out, 9 provinces schedule payments when the grantee goes to collect the monies.
Mr. Cassim, should you not be focusing on the problematic areas, though?
Chief Justice?
Why did you wait this long before launching the application for the extension of the contract?
8th of December, my client appreciates that this is going to be a problem area.
Why not earlier?
Because it's only on the 8th of December when the contract is finalized with the post office, as the post office says, I don't have the infrastructure to actually do cash payments throughout the 9 provinces. We have 5,000 pay points, but that's not going to suffice.
Was that new information? I thought post office had indicated the last time we were here what capacities they have, what pay points they had, and quite apart from the information they furnished us with, wasn't it incumbent upon SASSA to make its own investigation as to what is it that post office can offer, so that once a view is formed that post office is punching way above its head, then SASSA could look into the possibility of approaching this court when there is still time, rather than behaving as if it really wants to leave this court with no option but to extend.
Chief Justice will recall that in November, the Ministerial Committee takes over the negotiation of the contract with SAPO. There were problems with the contract with SAPO. Between SASSA and SAPO, there were imponderables where SASSA's view was that SAPO, South African Post Office, did not have capacity to take over this contract. And then comes the Ministerial Committee at Parliament level, supervisory role, and the Ministerial Committee has, among others, the minister in the presidency at that stage, members of National Treasury, and members of a number of other departmental people. They negotiate the agreement, finalize the agreement on the 8th of December, and on the 8th of December, that particular function is then excluded. So with respect, SASSA appropriately acts from the 8th of December. They start preparing the specs for the new tender. You have your procurement freeze period, middle of December to middle of January. Immediately, the request is issued mid-January. The first closing date is the 2nd of February. That's been extended twice, because on the 28th of January, when you have your compulsory briefing, there are 80 representatives. This is going to be a very sought-after tender, simply because you're administering over 3 billion rands a month. That's the value of this contract. And what happens is, if I may just give you the date, is then extended from the 2nd of February at the request of the people showing interest in the tender to the 28th of February, and finally the closing date is the 12th of March. So with great respect, I would submit that SASSA acted appropriately in the circumstances.
When were the papers filed for the extension?
Sorry, Judge?
When were the papers filed for the extension?
The papers were filed, Chief Justice. Give me the date exactly, please.
Okay, to make it easy, was it in January? Was it in February?
February, I report, Judge.
Why not in January?
Early February, 6th of February.
Yeah, why not in January?
You'll recall that the request goes out for the tender in 15th of January.
And it
Closing date is the 2nd of February.
Yes.
With respect, my clients thought that they could get their act together.
I just wanted to find out whether it could not be anticipated that the tender process was going to take longer, and while that process is lingering on, it might be necessary to approach this court
Well,
when there is still time, so that it's in a position to consider all the available options, if there are more than one option open to it.
Chief Justice, I can't argue the proposition, why wasn't it end of January? I can't argue with that, but it's beginning of February. Yes.
But Mr. Cassim, has SASSA not been aware since the 18th of December 2017 that it will require CPS cash payment extension?
In fact, they were away on the 8th of December when the agreement is concluded. That's correct. So what happens is we're looking at a tender, and I've said, Justice Kampepe, this is a major tender. I mean, everybody's interested in it because it's over 3 billion rands a month. If you take an economic analysis, and if my clients were being very practical, let's just look at it from this point of view. My clients were very practical and says, look, we're going to abandon cash pay points. As the expert says, you shouldn't have it unless within the 5-kilometer radius.
I'm sorry, Mr. Cassim,
Yeah.
I apologize for
Yes.
interrupting you. I know your time is limited, but my sister is virtually following up on what I was saying,
Yes.
which is this. And she's very specific. She said, when did you get to know that the extension would be required? You say the 8th of December.
I accept that.
Why didn't you immediately launch the application for the extension then?
Because by that time, what they started to concentrate is going out on tender. So they need the input of National Treasury. They're preparing the specs. It's prepared. The tender is ready to go out. You have a freezing period mid-December, mid-January. And to come back to this issue of this 2.8 million, the experts point out, they said you don't have to have as many cash pay points. You should only have it outside the region of 5 kilometers. But that's a policy consideration. If one takes an economic analysis, the amount it costs you to actually go to the pay points and to return from the pay point is probably...
Mr. Cassim, I apologize again. My
Chief.
point is simple. When you know as early as the 8th of December that you're going to need an extension, why wait until February before approaching this court? Why didn't you immediately, considering what transpired during the previous court case, why don't you immediately approach the court and say, I see danger coming our way. I don't want to look like I want to bind the court to do, to extend, I beg your pardon, CPS contract. When there is still time to reflect on options, I'm launching this application. Why was that not done as early as done while tenders were going out?
Chief Justice, I make 3 submissions. My clients were concentrating on the tender. The second submission I make is that there was the freezing period. And the third submission I make is they genuinely believe that they could get their act together. But I don't quarrel with the argument that as soon as you seek an indulgence from the court, you go to the court the moment you seek it. I don't quarrel with that proposition. I simply point out that in none of the opposing papers is another solution put forward insofar as that real problem exists. Everybody says we agree you need this service for another 6 months. But nobody says, had you come earlier, you could have avoided it. You can't because you got procurement processes.
No, but it's not known what we would have said had we been approached while there was still time as the court. It's one thing to focus on what your colleagues are saying. It's another to appreciate the need for the court to put questions that could point to another possible solution.
No, Chief Justice, I accept the principle.
Such as the possibility of capacitating post office by pouring resources into it so that it's able to do what is sought to be done by other entities. I'm just thinking aloud. I'm not saying we must address that one. I'm saying it may well be that the court could have put questions that could have led to a realization that the extension of the CPS contract is not necessarily the only solution.
Yeah, Chief Justice will appreciate that the post office challenge, which is really our challenge at this stage from 1st of April, is to convert the old cards to the new cards, bearing in mind the Easy Pay card, which has been already disseminated by CPS. It's there in the marketplace, it's convenient, but I don't argue with the principle that as soon as we require an indulgence, we should come to court.
Well, Mr. Cassim, I am interested in regard to the earlier period.
Sorry, Justice.
I'm interested in regard to the earlier period as to why SASSA only got to know in December that SAPO can't deal with this part of the matter. If I remember well, when this matter was before us last time, and it may even be the time before that, SAPO was saying they had the capacity to render the service that is required. Now, SAPO is a state entity. SASSA is a state entity. I don't understand why, soon after the matter was here before us, SASSA could not have said to SAPO, in order to be able to do this job, this is what you will need to have. Do you have it? And if they say yes, and they say, satisfy us that you have got it. Was that done? Was that not done? Why does it take so many months from the last time the matter was before court, before they know that there is something that SAPO can't do?
And to give a comprehensive answer, also to jointly approach Treasury or government and say, SAPO will need so much money. These are the capacities that would be required for it to be able to execute this mandate. While there is still time, government, please capacitate SAPO, make the resources available so that what it is not able to do as a result of lack of capacity or lack of resources, you can make possible by providing those capacities and resources.
Justice Mokheng, I have some insight into what happened in the negotiations, but let me just say this to you. Firstly, those negotiations was done at ministerial level. And everybody who matters was on that committee. You'll recall that features in the papers. The second is that, of course, there was a solution. There was a solution to buy over the trucks with the software that takes the money to the points. But the question was it possible for SAPA to do so? It was. Was it feasible? It wasn't, because of price considerations. You had to buy the infrastructure and the software from CPS, and there was no agreement on that. I don't want to take it further than that, but there was no agreement on that. So that left you in a position on the 8th of December when a decision is taken on economic principles. Look, we rather exclude this portion of the contract, otherwise it makes no economic sense, because you're also looking after the money that belongs to the taxpayer. So that then resulted in the 8th of December to say, we will excise this portion of 2.8 million. And of course, from an economic analysis point of view, if Justice Posner now from the United States would be asked the question, he'll say, but it's an easy answer. All you do is you force the recipients to open banking accounts. But that's not the policy that this particular client of this particular organ of state took. They took a policy to facilitate the payment, and they said, which now necessitates us to go out to tender and to bring in somebody who can do this particular service at a reasonable cost. But to achieve that, because you've got to follow procurement process, we then required an extension, and hence we 1st of February in court. That we should have come earlier, I have no doubt, because once you want an indulgence, put your papers into court. I accept that principle. But I'm simply saying that the solution lied in the negotiation process, and it's not to say that this is an imponderable of an achievement, but it was not feasible on economic principles.
Well, I'm not sure that what you have said answers my question. Did SASSA ask at the earliest opportunity after the matter was before us, did it ask SAPO whether SAPO could do the whole job? Did it satisfy itself? Did SAPO say, yes, we can do it? And did SASSA satisfy itself that SAPO could do it? I mean, I think the matter was here early in the year last year. Early in the year. And from the papers and from what you are telling us, since they discovered in December, I can't understand it, why it took so many months before they discovered that SAPO could not do this part of the job. So my question is, did they ask them early enough, do you have the capacity to do this job? Did SAPO say, yes, we do? And then later on it transpired they actually couldn't do it? Or did they not ask? Or did they not satisfy themselves?
Justice Zondo, it was always in the contemplation of the parties that this function will be performed by SAPO. It became impractical to do so because of financial considerations.
But
it's not
does that answer say they were asked and they confirmed?
Absolutely.
And
absolutely.
they confirmed?
It's not that it was beyond the scope of SAPO to do it. It's within their scope, it's within their capacity. It's not a difficult task. It's going out to tender. I've already told you there were 80 people who in the compulsory briefing who wants to tender for this project. But it's a question of, at that particular point in time, acquiring the software of CPS or of Net1. And that became impractical from a cost consideration, and hence the decision on the 8th of December by the Ministerial Committee, Justice Radebe, in fact, signed the agreement by them to say this particular portion will excise from the agreement. And from there, it became SASSA's problem. So it comes back from the Ministerial Committee, comes back to SASSA, and SASSA must now deal with it as the agent.
You see, Mr. Cassim, if one reads the papers here, and in particular I'm referring to the founding affidavit deposed to by Ms. Bengu on behalf of SASSA, one sees what appears to be a pattern where if you look at what steps are taken either by SASSA or the department to deal with issues that need to be dealt with, they seem to be taking their own time. They seem not to deal with matters with the urgency that the matters deserve. I mean, even if you look at this founding affidavit, you look at what steps have been taken and when to deal with issues, you see that there are gaps of 2 months, 3 months, when it appears nothing was happening. You don't get the sense that either SASSA or the department deals with issues properly. And that links up with the point that the Chief Justice was putting to you. You discover in December, early in December, that there is a need for an extension. But nothing happens until February. And in the end, some application is brought here. We don't normally, then we have to try and find time for it within our role. But when you look at it, there was time for things to be done early and to be done properly. But there seems to be an attitude that doesn't seem to care about dealing with issues urgently, that are urgent, and explaining things properly to the court. Yes. It's as if the attitude is the court has no choice, but it will give us what we want. So we don't have to give them a full explanation about what we have done about this. And that attitude is cause for concern.
Justice Zondo, I can assure you the SAPA people, the acting COO is in court. All the senior people are here, and they will obviously take into account.
And it's not a sentiment that is being expressed for the first time by me. It's a sentiment that other members of this court have previously expressed with regard to how either SASSA or the department or both are dealing with issues. I mean, I think the previous extension application that was brought before us also was brought very, very late. So it's cause for serious concern.
A side issue that I need to have cleared in my mind, I concede upfront that it's not central to the determination of the issue, but it's of some importance. So in a nutshell, it would be cheaper for a private company to acquire what the trucks and whatever that are too expensive for post office, a government entity, to acquire in order to render the same service.
Yes, it's the infrastructure together with the software package, because you recall the verification, which is a software package.
Even in the long term?
In the long term, yes.
Okay.
Can I make just two more submissions? And that is in terms of the SAPO contract, the payment which SASSA will make. SASSA made a payment of 16 rands 44 per transaction to CPS. In terms of the post office contract, it now makes a payment of 6 rand 71 per transaction. There's a saving of 9 rand 73, so there's a 58 million rand saving per month going forward in terms of the responsibility which SAPO has now taken over.
Even that won't help SAPO to acquire the infrastructure and the equipment it needs in order to render the service that is to be rendered by outsiders.
You can accept it that the amount that would have required to obtain the logistics and the software package was, for want of a better term, exorbitant in relation to the saving. But why I'm pointing out the saving of 58 million.
Mr. Cassim, could I ask you, what happens if the court does not grant the extension?
Justice Foreman, sorry, you've got to repeat that.
What happens if the court doesn't grant your application, doesn't grant the extension?
Then we have a situation from 1st of April where some 2.8 million people will be in a position where they go to their scheduled day, because payment is made in the first 12 days of a month. So take a place like Kokstad. It's made in a certain area on Monday, Tuesday, Wednesday. People will go there and there won't be monies available.
So you come to us basically giving this court no choice and saying that if the court doesn't make this order, the social grant beneficiaries will suffer. Is that what you're doing?
There will be chaos. They will suffer. Unless, of course, if they get their act together and they open a bank account, then that solves the problem.
But this is a result of the policy decision on your own version not to take other steps.
Yes. I mean, it was a policy decision to excise that particular segment of the services.
So if your policy decision has that effect, isn't the responsibility on your client to ensure, to take other steps to ensure that that debacle that you've put before us does not happen? Don't you have alternative plans?
As things stand at the moment, they don't have an alternative plan. But of course, it lies, the reality is, it doesn't mean to say that the recipient of the benefit is without recourse. It doesn't follow that.
The point is, Mr. Cassim, whose responsibility is it to ensure that the beneficiary receive payments of their grants?
There's no question it's SASSA's responsibility. That's in terms of the law. Can I just make one further point insofar as the other two issues are concerned? Chief Justice, if you want to hear me, the 700 odd There's just two other issues I just briefly want to make submissions. There's some 700 odd profit. You'll recall the debate between the experts whether transfer pricing and tax implications, but ultimately on CPS's version there's a profit just over 700 million. I would submit that it would be a quantum leap in this application if the court was to say that money must go to SASSA. Although SASSA wants the money, I would submit that that particular application is not ripe for hearing. We don't appreciate the course of action. And the other aspect is, insofar as the pricing is concerned, we would submit that CPS is now performing 1/3 of the function. It is the more expensive function because it doesn't rely necessarily on income streams. It actually relies on actual work, and we would submit that that price must be fixed by National Treasury, bearing in mind that we're no longer paying them 16.44 per transaction.
I thought you would avoid arguments that are supposed to be raised by CPS itself.
Yes, but I just want to make those points. Yeah, I mean, because I made those in my submissions, I've got to explain why we thought a fair and reasonable fee. I understand Mr. Marcus is saying that they should not. It's because we're no more paying them that 16.44. So we're saying the services they rendered. It's our responsibility to see they actually render the services. It would be foolish for us to expect somebody to take on this particular task under an order of court and not render it properly. We wanted the services to render properly, and they must be compensated for it.
I was just saying it on a lighter note that you wouldn't want to be misunderstood as fighting for CPS.
No, I'm not fighting for CPS, but I must do. If I'm not paying the 16.44 per transaction, which gives me a 58 million rand saving, they're no longer doing a 100% function. They're doing, give or take, a 28% function, perhaps a bit less. For that, there must be compensation. The question is, what must they be compensated? We submit, let National Treasury sort that out. That's our submission, consistent with the order. It's in my interest to see that these services are properly rendered for the next 6 months. Those are our submissions.
Mr. Cassim, do you accept then that SASSA failed in its duty to the court?
We've explained the circumstances under
No,
which
I
there was a
understand,
delay.
but my colleagues have put certain questions to you.
Yes.
You've accepted that you could have done it a bit earlier.
Yes.
And given the history of this matter, and I want to put it to you in fairness, because we have to deal with this in a possible judgment. Have you failed in your duty to the court or not?
Justice Kusalia, we're obviously working under trying circumstances. There's 12 billion rand available on a monthly basis. We have all the different forces working against us because it's not an easy matter. As we go out on tender, CPS has the march against anybody else who's going to tender because they've been rendering the services for the last 5 years. These are the realities of what SASSA is faced with at the moment. Now, to say what I can make this submission to you is, and I accept that we could have come earlier, but you bear in mind that there was this interposition, there was this ministerial committee that comes from Parliament that's interposed in the work of SASSA. So SASSA takes a step back. And if all things went right, if the SAPO agreement included this particular feature, then you transferred a substantial responsibility to SAPO, which would have encompassed all the activities, another organ of state, which would have bred new life into SAPO, and I would then have submitted we wouldn't have found ourselves in this particular position, but it was impracticalities that arose in the negotiation process which resulted in this particular hearing today. And to say, has SASSA failed in its duties? I would make the submission that they've acted to the best of their ability, accepted that they came a week or two late to court in carrying out their obligations.
Mr. Cassim,
Yes.
if I heard you correctly, you said that SASSA was facing various difficulties, and all the different forces were working against us. Can you clarify that statement, please? What do you mean?
On a practical level, if you just focus on this particular tender we're going out now, it's not that it's going to be smooth sailing, because there's 3 billion rand available. So you have the lobbying group for the banks who want utilization of the banks for this particular transaction. You have SASSA's responsibility to ensure that the entire grant is paid to the ultimate beneficiary, save for...
Sorry to interrupt you. What forces are you referring to that's working against SASSA?
That might have been a wrong word to use, but I'm simply saying there are challenges. There are challenges because when you're administering 12 billion funds on a monthly basis, dealing with the poorest of the poor, you have immense problems because you're trying to protect that money in terms of regulations. 10%, up to 10% can be spent on the funeral policy, not more. Any system you devise, you've got to avoid debit orders. You've got to avoid that amount being reduced by all forms of expenses before the money reaches the hands of the individual person. So I'm simply saying
isn't that the point exactly? That there are millions of vulnerable people who depend on social grants,
Yes.
and that SASSA should have acted more diligently.
Can't argue with that proposition.
Mr. Cassim, as you sit down, I want to make a comment. It seems SASSA continues to fail to get its affairs in order.
I'm sorry, Justice Kampebe?
I'm saying, before you sit down, I would want to make a comment. It seems that SASSA failed to get its affairs in order. It is a cause for concern that SASSA comes to this court almost like to blackmail this court that if it is not given an extension, then more than 2 million grant beneficiaries will suffer. You have no alternative that you can submit, you will resort to if this court should refuse to grant you an extension. Would that be a fair comment to make?
The facts are put before the court. And we come to the court for an indulgence because the matter is regulated in terms of an order of court. But this is the reality where SASSA finds itself. And as Mr. Justice Forneman said to me, look, if we don't give the order, it's your responsibility, and that is correct. But I said this, and I make this statement guardedly, and I thought it through. It doesn't mean it's the end of the world for the recipients because it's a three-way arrangement at the moment. There's an arrangement between the administrator, the donor, and the recipient. It's a question of what responsibility one wants to place on the recipient. And in Chapter 4 of the second Auditor General and a panel of experts reports, there's a very useful analysis why more stern steps, if not aggressive steps, must be taken to migrate this 2.8 million people to a structure that's regulated in terms of electronic financing. So When you say to me, Chief Justice, you say to me, is this not putting the court in an awkward position? It is, of course, because the court wants to ensure that this particular agency has a smooth sailing. But I'm saying we had to come to court. If we didn't come to court, we would be criticized. If we come to court, we're putting the burden onto the court. I understand that. But in the end, the challenge is really we working in the right direction, we're getting our act together, and there's going to be teething problems. Make no mistake, the migration of 6 people from one card to another card is going to be enormous problems, because we can't, nobody here can understand what the mind of the old card holder, the state of mind of the old card holder holding that card. I can't force people to come and exchange it. And if they come, it's a 10 minutes process. But what do? I've advertised, I've told people, but short of not paying them, which is probably the greatest incentive when they'll come and change their card, but short of not doing that, I'm really in the hands of unpredictability. That I can take steps to bring them to the party, of course, education, send my people out, but ultimately I can't bring a recipient or a beneficiary